Hello. Let's now turn to Article 3, which is a legislative article. This is extremely important section of our Constitution, and one that I fear you've not looked at before. Sadly, American law schools do not teach very much in relation to legislation, particularly state legislation. I'm sure you've had some contact with federal legislative processes, but now we'll deal with something that you will see much more often in your practice, and that is state legislation. And in this segment today, we will examine the principles, the constitutional principles that control the Florida legislature. So our objectives today are to understand the provisions of the Florida Constitution relating to the power and limitations on that legislature, to understand the organization of the legislature and the extent to which they're regulated by the Constitution. So let's get started with the beginning. And the beginning, in some respects, picks up from where Article 2 has taken us. Article 2 says that we'll have these branches of government. There will be separate branches of government, and you will not give powers to one branch that belong to the other branch. And Article 3, Section 1 tells us that the legislative authority goes to the Florida legislature. Well, that's simple enough. And with a few exceptions, it's true. We're going to find some examples where other organizations have what looks very much like legislative power, but for most purposes, we'll look to the legislature to develop state policy and declare that policy. And it'll do that through the two houses of the legislature, a House led by a Speaker of the House and a Senate led by the President of the Senate. Each of the houses also has an officer who is serving the membership, and that is the Clerk of the House and the Secretary of the Senate. So notice the different titles: Speaker and Clerk, the President and Secretary, but different titles in each of the houses. We have sessions of the legislature. A very good question on an examination is what types of legislative sessions are recognized in the Florida Constitution. We get a beginning answer in Article 3, Section 3, and that is we have organizational sessions and regular sessions. Organizational session occurs shortly after the election, which occurs every 2 years to elect legislators, and before an election year in which a governor is elected, before the governor is actually inaugurated, the legislature goes into what's called an organizational session, just to announce the committee appointments and to otherwise organize for the upcoming regular session. The regular session now is an annual session. Remember, this took place in the 1968 revision. Before that, we had legislative sessions every other year, but now we have legislative session each year. Starting date can be set by the legislature. We have organizational sessions, general sessions, and special sessions identified in Article 3, Section 3. And special sessions may be called by the governor by proclamation. Once the governor issues a call, that sort of sets the framework for the special session. That's their agenda. That agenda can be expanded or modified by a vote of 2/3 members of each of the houses. And a special session may also be convened as provided by law, and law now allows the legislative leadership to call legislature into special sessions. The regular session is constitutionally set at 60 days. It may or may not exceed that period. A special session is supposed to be limited to 20 days unless by vote of 3/5 of the members of both houses that is extended. And again, look at the requirement for 2/3 vote for expansion of the sessions or the agenda for the sessions. Limitations on houses adjourning without approval of the other house, and a provision in Article 3, Section 3, allowing adjournment by the governor. If the houses are not able to agree, the governor may adjourn the legislature. Section 4 on quorum and procedure. A majority of the membership of each house shall constitute a quorum, but a smaller number may adjourn from day to day to enforce the attendance of other members. And that's happened in Florida history, although not in recent Florida history. A requirement also in Section 4 for the meetings of the legislature to be public. There is an allowance for the Senate to meet in secret where they're considering appointments or considering removal from office, where the governor suspends or removes, and the Senate's to take action. That can be conducted not in public, but in practical terms, we've not had a secret session of the Senate for many years. Years and years ago, there was a session of the legislature relating to removal of a local official, and the press corps, led by a Miami Herald reporter, refused to leave the press gallery, and a Miami Herald reporter had to be carried out of the chambers physically, and that picture of the reporter being carried out by legislative marshals made the front page of most major newspapers in the United States and led to the culture which says that the Senate does not close its sessions even when it's permitted by the Constitution to do so. So John McDermott, the Miami Herald reporter, achieved, in practical terms, achieved a step for openness of government by his refusal to leave the chambers. It seems quite unimportant to see that that each house has to keep a journal of its own proceedings, but these, as we'll see from the case law, the journal carries special importance, and what's in the journal is the truth. That's the legislature saying this is what happened, even if in effect that's not what happened. If it says so in the journal, the courts in Florida will give deference to the legislature and to the legislative journal. A very important provision, and one that is very frequently confusing to law students, is that here each house is the judge for discipline of its members. Impeachment does not apply to legislative members. Or removal by the governor does not apply to legislative members. The authority to decide who is a member and who remains a member of the legislature rests with each house of the legislature. House makes that decision for House members, Senate for Senate members. So when you're asked what's the proper venue for a case challenging improper conduct by a state senator, the venue is always going to be Tallahassee, Florida, and the Senate of Florida. And so each house has that control, a member may be removed by a 2/3 vote of the membership of that House. Again, both the discipline of, issuance of reprimand or other disciplinary measures and removal itself rest entirely with the House. And the rules of procedure for each House shall be set by the legislature, but as to conference committee meetings and committee meetings, they should be open and notice should be given to the public. Look at that. That can be important in some circumstances where legislature does not live up to its constitutional duty. We sometimes, when we're talking about constitutional terms, we talk about clawback, and the clawback is the idea that you put forward some proposition and then water it down through later provisions. And in Section 4 on quorum and procedure, we have a clawback measure, and this is that each House may provide rules which now limit the openness that we thought we got in the earlier provisions. Section 5 on investigations, each House, when it's in session, may compel the attendance of witnesses and production of documents. I think in an earlier lecture I referred to an impeachment proceeding relating to justices of the Florida Supreme Court back in 1975. And it was necessary to keep going with that impeachment proceeding while the legislature was still in session, so that the authority to compel witnesses and to provide sanctions if witnesses did not comply with subpoenas, to have that power rest in the House of Representatives, which was conducting the impeachment investigation. But the reason there's necessary to act promptly was that that authority of the House to take action disappeared when the legislature was not in session, and at that point the authority to sanction witnesses who fail to appear passed to the courts rather than to the legislature, and can create a cumbersome process in trying to move forward an investigation. Section 6, we have a provision on single subject. Now, I said earlier when we were talking about the single subject requirement that's in Article 11 relating to amendments and relating specifically to initiative amendments, there's a single subject requirement there. That single subject requirement is construed by case law as to initiative amendments quite strictly. But the single subject requirement on legislation is not construed so strictly. So you really cannot use the case law from the amendments section of the Constitution, Article 11, to look at the requirement over in Article 3 relating to legislation. So don't confuse those two, and recognize that the courts have developed these separate bodies of law that relate to single subject in these two different contexts. Look at the requirements here, that you may not just simply refer to a section of the statutes and say that it's repealed or modified. You really have to spell it out so that people can see quite clearly what's being done with the legislation. Also, it has a strict constitutional requirement. To be legislation, it has to have this enacting clause. And this seems like it's a fairly simple matter, but a legislative procedure that used to be in vogue was, in legislation you did not like, you would move to amend the legislation with a simple amendment. You move to strike the enacting clause. If you were successful in striking the enacting clause, the legislation couldn't pass. So this procedure is not used, this technique is not used that much in today's legislature, but you can see why it was used. If there were a lengthy, complicated measure that's being put before the legislature, and you want to avoid this lengthy debate, and you think the issue can be simply resolved, you step forward when the bill is first offered on second reading for amendment, and offer this amendment to strike the enacting clause. It allows you to test the strength of the measure, and at some point, even if your motion to strike the enacting clause does not pass, it allows you to get a tally of the people who are supporting the measure and the tally of the people who are not supporting it, and do further work and maybe create other amendments that might appeal to those people who are not fully in support of the measure being offered. Section 7 gives us some further guidance on passage of bills. Unlike the federal Congress, bills may originate in either house. Remember that under the federal Constitution, appropriations bills have to originate in the House. That's not true in Florida. And appropriations bill, like other bills, may originate in either house. This Section 7 begins to tell us about the legislative process of readings, and essentially there are 3 readings of bills. The first reading is at the time of introduction, and a bill can be read by title only unless there's some objection. And so on first reading, what simply happens is the clerk of the House will read out the title of the bill very quickly. The presiding officer will then assign that bill to committees. It's now introduced and is before the legislature, and it starts through the legislative process. The bill then goes through committee or committees. It can receive multiple committee assignments in each house. And then after the bill clears all the committees to which it's assigned, it then comes back to the House on second reading. And second reading, the bill now can be read by title only unless legislators decide to ask that the entire bill be read, but typically it's read by title only, and it's open for amendment. Bills are today printed, available to people to actually read, and it's not quite as necessary to have these cumbersome procedures about open reading of the full text of the proposed legislation. Now, on second reading is now the occasion to offer amendments, and once that process is completed, the bill is usually moved on to third reading, which in modern practice occurs on a separate day. It's entirely possible for the legislature to take up the legislation on second and third readings on the same day, but it hardly ever happens in modern practice. We have a bicameral legislature, but we have a third player who's very important, and that is the governor. And in Florida, we have a governor who has a veto, and this veto now includes a line item veto in appropriations matters. So our governor may, in appropriations bill, may go in and veto not the entire appropriations bill, but individual items within the appropriations bill. And that's a power that is not given to the President of the United States, but a very important power, and one that, as we'll see, has been much litigated in Florida, and we'll have quite a lot of discussion about this in our upcoming class. This provides a period of time for the governor to exercise his veto power, and again, that has been subject to litigation, which we'll develop further in our class. After the governor's veto, the bill returns to the legislature. If the legislature is in session, it's given to the legislature. If the legislature is not in session, it's given next time the legislature meets, and the legislature then has an opportunity to override the veto. Overriding a veto requires 2/3 vote of each house. The bill, after veto is returned to the house of origination. So whatever house originated the bill will get the veto message first, and will vote on it and decide whether or not to override. Again, the overriding takes a 2/3 vote, and the Constitution requires that the vote of each member be recorded in the journals. The effective date of laws is very frequently spelled out in the bills themselves. If it's not, then there's a delay in the effective date until a later date, and it's the 60th day after adjournment of the legislature. And the reason for this constitutional delay is to allow people to see what has been passed and to adopt their own administrative rules or procedures to accommodate the changes in the legislature. This also obviously is important to criminal defense lawyers and to prosecuting attorneys because an amendment in the law will not become effective immediately unless that effective date is spelled out in the legislation itself. And if it's not spelled out in the legislation, then we have to wait 60 days to see that a revision of the law has become effective. We have provisions on special laws, and before passing a special law, you have to give notice that you're going to consider a special law. Now, that notice is not necessary where the legislation itself carries a referendum provision. So if there's going to be a vote of people in local government on the special legislation after the legislation passes, then you don't have to give notice. Otherwise, you have to give notice before legislation is introduced, and the legislature may not take up a special legislation that does not have a referendum and does not have a proper notice. And now we come to Section 11. Section 11 is going to be very important to us if we're in local government, because it is telling us what laws the legislature may not enact through the special law or general law of local application process. Now, first, a couple of words about the language general law of local application. What do we mean when we see that language in the Constitution? Well, essentially what we're talking about is what is popularly known as population laws. Population law. A population law typically might say something like, in all counties with a population above 200,000 but less than 800,000, the following laws shall be in effect. So if you look at the census data and figure out how many counties fit into that population bracket, you'll see that it now is general legislation, but restricted to only several counties. So it's general law in theory, but because it's of local application, not applying to all counties, it now falls within the categories of laws which must be looked at under Article 3, Section 11. So I'll look at this list. There's no way to get through Article 3, Section 11 without going through the individual provisions, but let's walk through them. There may be no special law or general law pertaining to the election jurisdiction of officers except officers of municipalities where you have a municipal charter, or where you have special districts or local government agencies. You may not have special laws relating to assessment or collection of taxation. You may not have special laws relating to evidence in any court. You may not have special laws relating to punishment for crime. You may not have special laws relating to juries or venue in civil or criminal cases. May not have special laws on conditions precedent to bringing any civil or criminal proceedings or violations of time, therefore. So restrictions also on refund of money paid or remission of fines, penalties, or forfeitures. That has to be done by general law affecting all counties. There are prohibitions against the creation or enforcement of liens, prohibitions on special laws relating to disposal of public property, vacation of roads, private incorporation or grant of privilege to a private corporation. So no special laws giving private corporations special benefit. Has to be done by general law. No special laws relating to effectuation of invalid deeds, wills, or other instruments, or any changes in the law of inheritance. No special laws changing the names of an individual person. That sounds strange, but in the past, we've had laws changing people's names. We've had special laws relating to divorce. It was not a special law in one sense, but there was a law passed on divorce that related to Henry Flagler. Henry Flagler's wife had some very severe mental problems, his first wife, and she was institutionalized in a mental health facility in New York, and the law was changed in Florida to allow people whose spouses had been committed to mental institutions to get a divorce, and Henry Flagler, having a great deal of power and influence for the legislature, was able to get that law passed, stayed in place for several years, and then was repealed. But there were earlier occasions when the legislature simply granted divorces, and that ends and is no longer permitted under the Florida Constitution. The adoption laws have to be general laws. Relief of minors from legal disabilities have to be done by general laws. Transfer of property interest to persons under legal disabilities, general laws. No special laws relating to hunting or fishing. Now, let's linger on that just a second. If a legislature enjoyed anything back during the time before the revision of the Constitution in 1968, it was legislators coming to Tallahassee and deciding what the game laws and fishing laws would be for their counties. And they would adopt these special laws. So if you'd like to have an extended dove season in your particular county, you come up and pass a special law. Now we're going to see later on in our review of the Constitution provisions that create a special commission that has the power to adopt rules relating to the game and fish regulations. And so Article 3, Section 11 tells us what the legislature cannot do, and actually it cannot, not only can it not pass special laws and laws, general laws of local application. Once we look at the full Constitution, we're going to see that the legislature is taken out of the whole process of regulating game and fish in large measure, and we'll look at that whole structure when we get to those provisions. There are prohibitions on the regulation of occupations which are regulated by a state agency. You may not go behind that through special laws or general laws of local application. And finally, any subject where the legislature passes a measure by a 3/5 vote to say that there should be further restrictions on the state legislature's authority to adopt special or general laws. Again, finishing off section 11, a requirement that there be reasonable classifications. Now let's move to appropriations bills. This is really very important part of our Article 3 study. How does the money get allocated? And the legislature, remember, either house may start an appropriations bill, and we have a requirement that the general appropriations bill will have law on no other subject. Well, that becomes extremely important for a number of reasons. And one is that it was quite fashionable in the legislature for a period of time to take a measure that you had attempted to pass through the legislature. It had been introduced, it had been assigned to multiple committees in House and Senate, that it had died somehow. And so when the appropriations bill came along, what legislators would do, I must say I myself was guilty at one time of doing this. Then Representative Bob Graham, later governor, was guilty of it on a number of occasions. We would take out of our desk the bills that we tried to pass, could not pass, and try to splice those into the Appropriations Act. And so those attempts were, many of them came before the courts ultimately, and the courts found that that process was not proper because there was an attempt to change the law by using the Appropriations Act. And the Constitution tells us that that's a no-no. And again, in our discussion of legislative article, we'll review that case law in some detail. Term of office, again, limited by the Constitution, shall be no more than 4 years, except as provided in the Constitution. And you're going to find that particularly when we get to officers who deal with education, that the Constitution allows longer terms than the 4 years. But if you're creating a new office of any kind, appointments by the governor may not appoint for longer periods than 4 years. 4 years is a limitation on term of office under the Constitution. Provision now, probably totally unnecessary, directing the creation of a civil service system. What if we didn't have this language? Could the legislature pass laws requiring a civil service system? Of course. It now is in the Constitution. The legislature has created a civil service system, and that language is really somewhat useless. Now we look at terms and qualifications of legislators. We learned that under the '68 Constitution, senators have terms of 4 years, House members have terms of 2 years, but that's not that quite simple. Think about what happens in reapportionment. We now, because we now attempt to have staggered terms so that some senators will have, at reapportionment, will get terms of 2 years, some will get terms of 4 years, and we'll begin to play, in this provision, play against the provisions of Article 6, which limit the terms of legislators and allow and require that no one run for office after they've served for 8 years. But if, as we'll see later, when we look at Article 6, and term limits, we'll see that it's possible for people to manipulate this system and to have and for senators to serve longer than 8 years, depending on what cards they're dealt at the time of the reapportionment. The qualifications: legislators shall be at least 21 years of age. There have been several legislators who have been elected when they were just 21. They have to be resident from the district from which elected, and shall have been in the state for at least 2 years. Now, vacancies. If there are vacancies in office throughout state government, vacancies on the Supreme Court, vacancies on the Circuit Court, vacancies on the state cabinet, state officials handling various kinds of duties, those vacancies may be filled by appointment, but not legislative vacancies. Legislative vacancies are always filled by election. And to determine the validity of the election, you go not to the courts, but go where? You go to the House, the legislature. The legislature will, each house of the legislature shall determine the qualifications of legislators. So any election contest relating to an election held to elect a member of the House of Representatives goes to the House of Representatives, and it's decided there. No appeal, no review by the District Court of Appeal of the Supreme Court. It's a decision made by the legislature, and the legislature has exclusive jurisdiction over that set of issues. Now, there are possibilities that cases of fraud or where legislators' constitutional rights are being violated, as they were some years ago in Georgia when Julian Bond was kept from service in the Georgia legislature because he was a strong opponent, outspoken opponent of the Vietnam War, and Georgia legislature tried to keep him excluded from the legislature. That was not allowed, and there's U.S. Supreme Court authority on that point. Legislative apportionment. We now get into a really interesting area, one that is still very lively area for dispute. Note that this now deals with legislative reapportionment and does not specifically deal with congressional apportionment. Or what we're dealing with is what the state does in developing the lines, the boundaries of the districts for state senators and state members of the House of Representatives, not for congressmen. But that's not included in this provision. And we now have a legislature in 1968 which has had a great deal of experience with apportionment. Remember that there have been a series of cases in Florida following the decision of the U.S. Supreme Court in Baker versus Carr, and in the on into the late 60s and early 70s, there were a series of cases that were involved, federal cases that related to the apportionment of the state legislature. And as I think I said in an earlier lecture, I was originally elected legislature for the second time to serve my first term, but my second election was under an apportionment plan that was announced by a federal judge, and not a plan that was developed by the legislature. Federal judge found the plan under which I was originally elected to be unconstitutional, and actually that decision was made by the U.S. Supreme Court, and necessary to have a new apportionment plan, and it was done by a federal judge. Well, the legislature had a great deal of experience in going through apportionment, and therefore wanted to see the state conduct its own process. So we have a process first described about what the legislature shall do. There's a provision relating to the governor, what the governor shall do in case the legislature does not act, a provision relating to judicial review, so that there shall be a review. Even if the legislature does act, the Attorney General of Florida shall then petition the Supreme Court of Florida to review the apportionment process. And remember the sequence. There's a federal census. We'll see in Article 10 that we use the federal census for purposes of determining how we apportion. And following the federal census, which takes place every 10 years, we have a legislative session. And typically, usually 2 years after the federal census, we get around to full apportionment and review by the courts. And so in 2000 we had a federal census. 2002 we have action and litigation. In 2010 census, 2012 action, litigation in the Supreme Court, and some of that litigation goes forward for reasons that we'll explore a little bit later in this lecture. But look at the roles. Legislative role in apportionment, a gubernatorial role if the legislature does not act, and ultimately, if they do act, a judicial role which allows the legislature, legislative action to be reviewed by the Florida Supreme Court. And so subsection D begins to wrap up that section. And again, section 16 allows for the governor to come back into the act if the Supreme Court determines that the legislature has apportioned in a way that's not constitutional. And look, again, this relates to legislative reapportionment, and there are times, again, for the legislature to go back and look at apportionment. And if the legislature goes into an extraordinary apportionment session, there then is consideration by the court and review by the court once again. So again, as you look at Article 3, Section 16, remember that we're adding some types of legislative sessions. We've seen earlier that we have an organization session, a general session, a special session. We now see a session that is devoted to apportionment. So we have a reapportionment session or an apportionment session. And if there's failure of the first process, a second called an extraordinary apportionment session. So multiple types of legislative session embodied in the Constitution. So let's move from legislative apportionment to another topic. We'll have to return to legislative apportionment in a minute, but let's touch on impeachment because that's next in sequence in the Constitution. And if you've got your state constitutions open, I hope you'll look at this language closely. Impeachment. We've already said you do not impeach a legislator. Legislator is not impeached. So who is subject to impeachment? The governor, the lieutenant governor, members of the state cabinet who are elected statewide, not the governor's appointees to executive offices that are not the constitutional cabinet officers, and then judges. What judges? The answer in Florida today is all state judges. Everyone who serves on a state court in any way is subject to impeachment. And this, now, listen to my words carefully. I said state court. That does not relate to judges of workers' compensation or judges who deal with unemployment compensation. It deals with the judges of courts. And so the county judge, circuit judge, district court of appeal, Supreme Court justice, all of those are subject to impeachment. And we have an impeachment process which is seldom used, and seldom used with judges because we have in place the mechanism of the Judicial Qualifications Commission, which we'll look at more closely when we get to Article 5. Provision in Article 3 tells us that anyone who is impeached may not perform any further duties until the resolution of the impeachment. Remember the process. The process is that the House impeaches by 2/3 vote. The issue then goes to the Senate for trial, and the Senate tries the facts and makes a determination finally about whether the officer should be impeached. So it's almost like a grand jury, where the House of Representatives serves as a grand jury, and the Senate serves as a trial jury, and that's exactly what happens. And I've recounted to you earlier our experience with impeachment in Florida, particularly the impeachment which relates to the justices of the Florida Supreme Court back in the 1975 in that region. Voters, as I've said earlier, voted to impeach Justice McCain. Justice McCain had been appointed by Governor Kirk to office, proceeded to conduct himself in ways that were inappropriate for a justice. Investigation into Justice McCain revealed the distinct possibility that he had been bribed by people who had cases pending before the court, and he was ultimately impeached. I'd said earlier that it was necessary during the impeachment process, when I was serving as chief counsel to the House Judiciary Committee, which was charged with the impeachment process, necessary to go visit with Justice Atkins to let him know that because he'd served on cases with McCain when certain opinions of McCain had been issued, it was necessary to ask him to step down and not preside at the Senate trial, even though he was Chief Justice. And we informed Justice Atkins that Ben Overton was the most senior justice who had not served with McCain, and that he would have to be the person presiding when the Senate trial took place. And so, sad story of Justice McCain. What I bring to you now is a news article from 1986. It reports the terrible facts that McCain, who was so talented, was really such a nice guy to meet him and get to know him. The law clerks who served in the Supreme Court viewed Justice McCain as one of the better liked justices of the court. He paid attention to the law clerks. He had a great political sense. He was smart, but he made the mistake of leaving the proper course, became involved in corrupt activities, and was subject to impeachment. He ultimately was disbarred. He was ultimately charged with federal crimes, including drug running and arms smuggling. He was a fugitive from justice for a number of years, and finally, at the end of his life, he checked into a Jacksonville hospital, died, and was identified through testing to be the disgraced justice of the Florida Supreme Court. a result which I view with some horror, but as a great moral lesson for people who are extremely good law students and who are on their way to the great distinction. Make sure you don't step off that road in the way that Justice McCain stepped off that road. We have provisions in Article 3 for conflict of interest provisions. Again, this is probably not a particularly useful provision in the Florida Constitution, but it now directs the legislature to adopt rules of conflict of interest. You'll notice that this language is greatly amplified in Article 2, Section 8, relating to ethics in government. We now have provisions in the state constitution which are fairly complex, really are not likely to be used very much by you, but let's go through to make sure you understand that they're present in the Constitution. A couple of them are extremely important, but they attempt to set out the process for budgeting and planning, and set out a process that now requires special votes of the legislature. 3/5 of the membership of the legislature must act on appropriations for recurring purposes that are in excess of the percentage of funds appropriated in the past. So recurring revenues mean these revenues that keep up expenditures for ongoing state expenses, as distinguished from capital expenditures for construction of buildings or other activities that are one-time expenditures. Budget requests are, again, this constitutional provision can be impacted by general law, requires a look at the long-term prospects, requires that agencies submitting their budgets look long-term. Provisions of our Section 19 require certain formats and itemization of items, and requires an itemization, particularly of appropriations that exceed $1 million in 1992 dollars. Again, Section 19 gives deadlines for the appropriations process, and again, a very important provision, one that I think has been a great improvement in the legislative process, although I don't have much brief for much of what was before in Section 19. This provision, which requires the appropriations bills to be available on the member's desk at least 72 hours before final passage. So it puts a brake on the appropriations process and allows legislators the time to look through these very lengthy bills that have a number of measures, and to work with legislative appropriation staff and others to allow legislators to come to some understanding of the legislation before it comes to a vote. Preparation of the bill continues on. Provisions relating to trust funds. If we deal with trust funds, this now limitation on the creation of trust funds, we might say a word about the legislative treatment of trust funds. And that word is, there's no trust. Legislature has shown no inclination to trust trust funds. So that if you label something a trust fund, just because you've got that label on it doesn't mean that the money is going to be used for the purposes for which the fund was created. Legislature may very well intrude into that trust fund and use the revenue in that trust fund as general revenue, and the legislature has done that repeatedly. most notably in terms of the lottery trust fund, where trust fund was created a lottery, education lottery trust that has been entirely displaced by the legislature. Legislature withdraws that money and puts that money to the uses of general revenue, so it diverts the trust fund. And the legislature's diversion of trust fund has now happened so often that no one should give much attention to the fact that something is designated as a trust fund. Section 19 continues with limitations about trust funds, some exemptions relating to trust funds, but I've already said what I think is important about legislative trust funds. There is, at the very end of Section 19, this budget stabilization fund, which asks that the legislature provide funds that would be held in reserve, that would allow the budgets of the legislature not to bounce too much between times that are good and times that are bad, and that there be a fund created that allows for stabilization of the state budget. And I view that also as a very good thing. Processes for long-term planning provisions, which are in the Constitution but are not always adhered to. Establishment of a government efficiency task force in 2007 and every 4 years thereafter. Some language in Section 19 relating to the composition of the Legislative Budget Commission. And now we get to something that is, I think, extremely interesting, and it goes back to apportionment. And here we have to look at the fact that there were no standards in the Constitution that gave guidance for apportionment. And now finally, with what's called Fair Districts Amendments, Amendments 20 and 21, we now have standards for apportionment. Section 20 will lay out the standards for legislative apportionment of the legislature itself, and Section 20 will lay out standards for congressional apportionment, and Section 21 will lay out the standards for legislative apportionment. So 20 for congressional apportionment, 21 for legislative apportionment. The language in the two sections is virtually identical. So when you read the language in one, you really can comprehend the language in both of them. And it requires, as you look at this language and begin to take it apart, it requires, first of all, that no legislation be adopted, no district shall be drawn with the intent to favor or disfavor a political party, or two, an incumbent, and district shall not be drawn with the intent of denying or abridging the equal opportunity of racial or language minorities to participate in the political process, or to diminish their ability to elect representatives of their choice, and district shall consist of contiguous territory. So note how many standards we've got here. The standard that you shall not favor or disfavor a political party, or favor or disfavor an incumbent, shall not abridge the equal opportunity for racial minorities. You shall not draw districts that do not consist of contiguous territory. So how do we apply these? Well, the amendment tells us how to do this. Unless compliance with the standards of this subsection conflict with the standards in subsection A or subsection B, districts shall be as nearly equal in population as is practical. Districts shall be compact, and districts shall, where feasible, utilize existing political and geographical boundaries. So now we have standards that are added in subsection B. But subsection B tells us that subsection A is the controlling section. You have to comply with subsection A, and to the extent it's possible and practical, you have to comply with the provisions of subsection B. But we now have this set essentially of 6 standards, 3 of which are embodied in section A, and you now do not allow the legislature to apportion with improper intent. So let's begin to see where this takes us. Again, subsection C tells us about how we look at subsection A and subsection B. So we've got all the guidance we need. Section 21 essentially repeats the provisions of section 20, really has the same provisions in that section. But it now leaves us with a very important question, and that is, we now have provisions in our Constitution which say the legislature may not apportion with improper intent. Well, traditionally, you do not look at legislative intent when legislation passes. If I'm a legislator who voted on a bill that passed during the time I was in the legislature, I'm not competent to testify about what that legislation means, because it doesn't mean what I said. It means what the legislature says. And looking at legislation, the courts will not look at individual legislators and what they thought they were doing, but will look at what's expressed by the legislature in the legislation itself. But now we've got a constitutional provision that says that improper intent to favor a political party or favor an incumbent is improper. It's unconstitutional. And so we now faced with a litigation that now attempts to enforce this provision of the Constitution, and we're dealing with a 2013 case of Florida legislature being sued by the Florida League of Women Voters. And this case went to the First District Court of Appeal, went before the trial court. The trial court found that it would allow limited discovery of legislators. It went before the First District Court of Appeal, and by a 2-to-1 vote there, the First District Court of Appeal said that there is legislative immunity, and legislators may not be compelled to testify in depositions or otherwise. And the case then gets to the Florida Supreme Court. And this now is an argument before the Florida Supreme Court.
Your Honor, it's possible that this court could draw an order saying you could get to objective facts and describe the objective facts. At this point, we're not sure exactly how the objective-subjective line gets drawn. And so we can't entirely answer you, and therefore, we're a little bit uncomfortable with that and think it's unnecessary. Why do you have to have any rule that's different from any other rule once intended?
Let me ask you a question about how this fits in the overall body of the law. Do you have any cases where a court in the United States has ordered that a member of a state legislature submit to a deposition in a civil case to answer questions concerning matters related to the deliberations of the legislature and things internal to the legislative process?
Your Honor, I think the strongest case that we've got, there are 2 important cases, but Baldus from Wisconsin.
Does that case do that? If you've got similar cases or cases you think should be persuasive, you can tell me about those. But are there any cases that fall in the category that I described?
Not in terms of an assertion of legislative privilege, in terms of executive privilege, a number.
I'm not talking about executive. I'm talking about legislators being required to submit to a deposition in a civil case related to matters within the legislative process.
No, Your Honor.
You don't have any cases like that, do you?
No, Your Honor. And so Baldus was an assertion of legislative privilege to protect a legislative staff person, an assertion very similar to the assertion being made by respondents
So you've got a case that involves requiring that a staff person.
That's right. But, Your Honor, the Constitution is drafted saying that the prohibited action is legislative, intentional legislative favoring of a partisan purpose. So it's not directed.
In fairness, Mr. Dellenberg.
I'm sorry.
In relation to Justice Kennedy's question about whether there are any case law that deals with this legislative privilege, are you aware whether or not there are any other states in the country that have an amendment such as the one that's at issue here today that requires a look into this intent issue?
No, Your Honor. Florida stands out as the sole state in the United States.
So there shouldn't be any case law developing yet.
And there's not, you won't find case law in other states relating to a constitutional provision that prohibits wrongful intent.
So you're saying that
Florida is the only state that has such a provision.
Are you saying that there's no other state constitution that has a provision similar to the provision at issue here?
Your Honor, you have to tell me what similar means, because there's
Well, I'll
state
just leave it
constitution.
at that. You're saying there is no such constitutional provision in any other state constitution?
That does protect against this wholesale, the why questions, but allows things that in the ordinary course of how this plan was developed for there to be some discovery on it.
Well, the order, although it seems to try to be fair, it has the same chilling effect as an order saying you can depose regarding anything, because legislators are still going to be reluctant to do anything to get involved in this redistricting process if it means now I'm going to get deposed.
Well, maybe next 10 years they won't, if there is evidence that it really wasn't quite as transparent as the legislature said it was, maybe 10 years from now it will all be transparent.
But that's not the point.
Well,
they're not going to take our word for it.
But the point is that we adopted and we approved the entire House plan and most of the Senate plan and reapproved the Senate plan, understanding that what had been presented showed indications that there was never an improper motive in how the lines were drawn.
We're not saying that they're not entitled to discovery. We've never said they're not entitled to discovery, even though they say that's what we've done. We have produced over 33,000 documents. The Public Records Act of the state of Florida circumscribes the legislative privilege so that anything that's a public record, they have gotten. The only thing that they don't have is depositions of legislators with which, despite the requirement of intent in other statutes and the Voting Rights Act and Equal Protection, have never been ordered in this country.
Let me ask you that about the documents, because I was trying to trace through where the protective order. So although he talks, I don't find that all that difficult
Well, Your Honor,
to
but now
understand.
that assumes that now we're going to have depositions. And how many legislators
I understand that, but I guess you were
depose?
saying it was unworkable, and I just didn't think
It's just like saying, well, we're not going to call a judge in to determine how he decided a case, but we're going to ask him how many times he talked to his law clerk and what his law clerk did.
Well,
That's
if it was the next
objective
part,
information.
that would be, again, now we're really going outside of what the constitutional amendment called for and why this inquiry is relevant. But I appreciate your advocacy and your argument.
Okay, Your Honor, unless the court has any further questions.
Thank you for your argument.
Thank you.
Rebuttal.
Thank you, Your Honor. If there's time, I'd like to make about 3 points. First of all, on privilege. Even respondents do not assert that the privilege is absolute. They concede that in some circumstances, that is, criminal law inquiry, the legislative privilege does not exist. They cite Gerardo, and it's clear that there are some things that will trump the legislative privilege. It's our submission that where you have a constitutional provision that prohibits certain types of criminal intent, of legislative intent, that is partisan intent, intent to intrude on minorities, you may also inquire of legislators. The second point I'd like to make is the point that was made by Justice Pariente about separation of powers. Let's think about separation of powers. We have a constitutional amendment. The duty of the legislature is to abide by the provisions of the Constitution. And the judicial role is to interpret that constitutional provision and to apply it in a way that it has meaning. And that includes allowing information about the process as it took place. The third point I wanted to make was a point about chilling effect. Counsel argues that there be a chilling effect. The constitutional amendments adopted in 2010 were intended to chill the legislature. It changed what legislature could do. The legislature could no longer do what it did in 2002 and adopt a plan with the intention of favoring a partisan party. Those types of intention were declared to be unconstitutional in 2002, in 2010. And we respectfully submit that to implement these constitutional provisions, you have to allow inquiry, including inquiry of legislators. Thank you very much, Your Honor.
Thank you for your arguments.
More of that argument than you wanted to hear, but I thought it was a very interesting argument. A couple of points about what you've just seen. One, notice that quite early in the argument, Justice Kennedy really comes after me very hard on a very significant point, and that is that no court previous to this has ever required legislators to give deposition testimony or to testify. And in that, he's absolutely correct. But of course, this was the first case that contained constitutional language like that contained in the Florida Constitution to reach any court. There are now provisions in other states that are very much parallel to Florida's constitutional provision, and I predict that there will be other cases that will follow the decision in League of Women Voters versus Florida legislature. Another observation, I hope you observed the exchanges between Justice Pariente and Raul Quintero arguing for the legislature. You know that Raul Quintero is a former justice of the court, and in my judgment was an extremely good justice, very smart, extremely honest, just a terribly decent guy. He's an FSU graduate who went on to Harvard Law School, smart as he can be. If I were the legislature looking for somebody to argue my position, I think I would have chosen Raul Quintero. He's as good as he gets. As you watch the body language in the exchanges between Justice Pariente and Raul Quintero, you might think that there's some hostility between the two of them. And that is not at all true. When Raul was on the court, I believe he would say that his best friend on the court was Barbara Pariente. They did not always line up on the same side of litigation, but in terms of personal relationship, they enjoyed one another very much, and this is demonstrated in a number of ways over the years. The other comment I'd like to make is when you're in an argument and a justice starts asking a question, recognize that it may be a Lombarga type question that I got. So Justice Lombarga steps in at the time when I was really under fire by Justice Kennedy, and in some part at least rescues me. And then I guess I want to comment on the final opinion. There are very few times when you argue cases and then later read the opinion and you feel like you can trace something that was said in oral argument to a provision of the opinion. It happens sometime, And in my judgment, it happened here. And the issue, remember, was former Justice Quintero was arguing that to approve legislative testimony, to allow legislative testimony, would chill the legislature. And my rebuttal argument was that that was the purpose of the amendment, was to chill the legislature. And so here's what the court writes in Justice Pariente's opinion. Although the legislature, as well as former legislative presiding officers in their amicus curiae brief, assert that there's a chilling effect will result if legislators are compelled to testify in this case, we reject this argument. In doing so, we emphasize that this case is wholly unlike the traditional lawsuit challenging a statutory enactment when the testimony of an individual legislator is not relevant to intent as statutory construction, and there are few, if any, compelling competing interest weighing against application of privilege. Further, we observe that the major chilling effect asserted by the former presiding officers would be the alleged reluctance of legislators to meet with constituents or discuss private or intimate matters free of fear of private conversations becoming public. This example is obviously a far cry from this case, which involves nothing less than the public's interest in ensuring compliance with a legislative mandate in a process that is described as the very bedrock of our democracy. So Justice Pariente accepts the idea that a purpose of the constitutional amendment is in effect to chill the legislature from the kind of activity that it was engaged in earlier. Just as a historical note, following the apportionment of 2002, which followed the 2000 election, there was litigation then, and the legislature in the 2002 litigation admitted candidly that it had tried to take care of partisan interest when it adopted the legislative apportionment plan. Well, that kind of intent today would be absolutely prohibited by the Constitution if we're going to enforce the Constitution. And the only way we're going to enforce the Constitution is to require discovery and testimony of the people who developed the plans and drew the lines. So there we have a constitutional case that got to the court from the trial court through the First District Court of Appeal and was resolved by the Florida Supreme Court in December of 2013.